This is Office Talk with Annette Stepanian. In today's Office Talk, I'm going to be answering a question that has come up a few times during my free legal webinars. The question has to do with contracts and electronic signatures. More specifically, is an electronically signed contract valid? But before we get started, I do have a disclaimer, and if you've listened to a few of these videos, you know the drill. This presentation is for informational and educational purposes only. It does not constitute legal advice and is not guaranteed to be correct, complete, or up to date. This presentation doesn't form an attorney-client relationship between me and you. The law does vary from state to state and based on your individual circumstances, so if you have any questions, definitely contact an attorney authorized to practice law in your local state or jurisdiction. So here's the common scenario for most people when they're in the process of signing with a new client. You draft your contract, send it via email to the client, and ask for them to sign it. Your client might print it out, sign it, and scan it into a PDF and email it back to you. Or maybe they use one of those e-signature services, so all they have to do is just type in their name where their signature is supposed to go and then send it back. Regardless of the method that they use, the point here is that you're not signing or exchanging paper versions of the contract with one another. So the question is an electronically signed contract valid? The short answer is yes, but this is the law, so there's always a few exceptions, which we'll dive into next. So in the United States, the rules regarding electronically signed agreements primarily derive from two acts. The first is on the federal level called the eSign Act, and the second is on the state level called the UETA, or the Uniform Electronic Transactions Act. So the purpose behind the Federal eSign Act is basically that a contractor's signature may not be denied legal effect, validity, or enforceability solely because it is in electronic form. The reality is we live in an electronic age, and if electronic signatures were invalid or unenforceable, could you imagine the administrative burdens that would be imposed on businesses in this country and around the world? But a note of distinction here. Just because these laws provide that an electronic signature cannot be held legally invalid, it doesn't relieve a party from having to prove the authenticity of a signature on a contract. So what is an electronic signature exactly? So for example, pasting the scanned version of the signature into a document, or printing out a copy of the document, signing it in ink, then PDFing it and sending it over to the recipient, signing on a tablet with your finger or a stylus, or other electronic acknowledgments. For example, when you click an I accept button, you enter your initials in a box, or you type your name onto a signature line. The format of the signature is not what's important. What's important is that the person who is signing the contract electronically is conveying his or her agreement to the terms of that document. So can an electronic signature be used for everything? The answer is no. Under the eSign Act, there are certain types of contracts that must be on paper. I suspect that for most business owners, these types of contracts won't be at issue. However, in the interest of being complete here, I'm just going to run through these contracts really quickly. These include documents dealing with adoption, divorce, and other family law matters, wills, codicils, testamentary trusts, notices of utility termination or cancellation, foreclosure notices or eviction notices, court orders, notices and other court documents, notices of termination of health or life insurance benefits, notices of product recalls due to health or safety reasons, and documents required by law to travel with hazardous materials. Under the eSign Act, a consumer has a right to not use electronic signatures and instead use paper signatures. A consumer must also be informed of his or her right to receive a written record and must consent to the use of an electronic signature in a manner that demonstrates that the consumer can access the information in the same electronic form that will be used to get his or her consent to the contract. So that's a really complicated way of saying that if you're going to require a customer to submit an electronic signature in a certain format, you have to make sure that they have access to that format. So for example, let's say it's going to be via email. They have to have the hardware and software, for instance, to be able to access that content via email. So one last tip. If you're going to be using electronic contracts in your business, make sure to save a copy of your signed contracts. Don't just let them sit in your email inbox or store them in the software program you're using to facilitate electronic signatures. Always download a copy and either save it to your hard drive or print it out and put it in your client files. So that's it for electronic signatures. It's probably more than you ever wanted to know about them, but if you have additional questions about them, or if you'd like to ask a question about law or business that you'd like me to address in a future office talk, submit your question over at AnnetteStepanian.com/Q&A. Looking for more resources? Well, make sure to stop by my website over at AnnetteStepanian.com. There you'll find contract templates for your creative business, free legal webinars, upcoming courses, and loads of other goodness to help get your legal groove on. And while you're there, sign up for my free weekly newsletter where I share my best tips for laying the legal foundation for your business.